All right, are you Shadamon Mitchell? And will your client waive the formal reading of the indictment?
She will.
Yes,
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes, ma'am.
Okay. I'm
but we're okay with.
inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today, since y'all have the restitution amount?
Judge, she doesn't have a criminal record.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes.
So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months, and all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation, and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again.
I'm sorry.
I don't need to see your belly button in court.
Oh, yes, ma'am.
Okay? You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way, and dressing like that is not an adult way to show up to court. Okay? You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay? Good luck to you, ma'am. Thank you, Mr. Comerford. Good morning.
Judge, we are winding down on this. We got an offer since our last court date.
Okay.
It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if that's something that we could come up with up front to help resolve the case. I did find, I looked and couldn't find them. I did find though the proof of services for that 80,000, so we need to go through it. He has
Okay.
not seen it. That was added in discovery at a later date than when he came to my office the first time.
Okay. Any issue?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right, and so y'all have got
So we
everything's
finally
here,
that.
you've got it all?
Everything's here.
Okay.
The offer's been sent, we should be.
Perfect.
Done today.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Galmore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take, okay? All right,
Judge.
thank you.
And just like that, the judge shifts from compassion to business. Watch now. This is where every word starts to matter.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to.
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine? And this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoffpower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to him by email, Stephanie.
Okay.
Hines, but we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me
expect
an
them?
update, But, it was Friday.
Okay.
when I got last contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record,
Good morning, Mr. Rojas.
Morning, Your Honor.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Are we going on count one? Oh, no?
No, ma'am. we're
Okay,
Everything.
okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge, I'm
do we
looking
just
at
need to
the
go on one, or
Let's
is
just
that?
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
It
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
Attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for a pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced,
15
but,
and 99 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count one only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I'll also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to
This is the heart of Courtroom deals guilt paperwork and consequences wrapped in calm voices. But behind every yes, sir, is a life about to change.
trial, or if you change your mind, you can plea open to the court or to some different plea agreement unless there is new information that your attorney or the district attorney's office receives. Do you understand?
Yes, ma'am.
Okay. If you'll just have a seat, she'll call you up in just a minute. Good morning, you're Nakia Brandon. So, Mr. Brandon, you're ordered to have a drug patch, and it looks like you've had some issues with that. Have a seat in the jury box. We're going to get you tested this morning. TJ Landry, looks like that's set for a plea.
I had a motion to withdraw, last week, yeah. He's been having a lot of financial difficulties.
Hold on. All right, this is 24 DCCR 0165, your TJ Landry. And this, it's been going on for so long.
If you need me to move it, I'll move it. But I've been patient with Mr. Landry to, fulfill his financial obligations, and he just,
Are you working?
I'm working, it's just that I was in custody and I was out of work for like 2 weeks because she made 3% my car and the money I have for her to pay her, I used to get my car, so I had transportation, that's the only transportation I have. I ended up calling her ahead of time and told her, hey, I got my money to make the payment. I called her ahead of time. And then I ended up going to jail for expired registration tag on my car. So I had to pay for my title to be transferred.
The thing is, if he qualifies, it's going to be you because you were initially appointed, which isn't super fair, I understand. Y'all have something worked out?
If there's an agreement for probation, I think the state is asking for straight, we're asking for deferred.
Okay.
I'll get the paperwork.
Yeah, it's gonna be either way. I don't, on this one, just because where are you working?
ExxonMobil right now. I just got into one.
When did you just get back to work?
Thursday last week.
When is your next payday?
Thursday. We get paid every Thursday.
What I'm inclined to do is, even though it's been going on, is reset it one time to give him some time to take care of some of the obligation to you, Ms. Holmes, and then we'll take care of it at the next court date.
Yes, ma'am.
I should be okay because I took
You need to
care
take care of Ms. Holmes. She's been working on your case very hard, and so it sounds like she's got a good offer for you. And now that you're working and you're working full-time, I would expect you to hire someone. You've done that. You need to try to take care of that obligation. I'm going to reset it 30 days. I want you to get with her, take care of as much as you can with her, and then we'll take care of it at the next court date.
Yes, ma'am. Thank
Okay.
you.
Thank you.
Thank you, Judge.
All right, you're Edmund A. Latulis, and this is 24 DCCR 2057. Ms. Latulis is charged with abandoning or endangering a child, and what is the announcement?
Yes, Your Honor. So there's a co-defendant involved. Spoke with Mr. Hoffpower. He would like to meet with both me and the co-defendant's counsel.
Which I spoke to Mr. Burbank, who's here.
Okay,
Like, we want to hold off on our announcement and make sure that we're doing that, but I think we have a resolution, but due to the nature of the facts of this case, which is a dead child, that's why I want to make sure we cross
right.
every I.
Well, and this one was, I have a notation that this one was going to go before the other one
Right.
anyway.
Right.
Oh, I
But
didn't know that.
she needs to talk to her client about what our offer is in regards to.
Yeah, I was
Right.
getting offered this morning.
Oh, okay.
Right. Now, we've spoken.
Okay, so let me do this. I'm going to reset it, just a normal reset.
Okay.
That way you can go over any options with Ms. Latulis. Y'all get together, Mr. Burbank, Mr. Hoffpower, y'all have 30 days to take care of all of that, and I want an announcement at that next court
Yes,
date.
ma'am.
Okay?
Okay.
All right, Ms. Latulis, stay in touch with Ms. Holmes, because you're going to need to go visit with her before the next court date.
Okay.
Good morning. Are you Zelly Valasila? And Ms. Holmes, will your client waive the formal reading of the
She
indictment?
will, Your Honor. And I'll email the attachment.
Oh, thank you. And Ms. Valasila, in cause number 24, DCCR 1364, you're charged with a second-degree felony offense of burglary of a habitation from May 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 7 years in prison.
Yes, ma'am.
And what that means is that you're leaving your punishment up to me. And as long as I don't give you more than 7, you're waiving any right to appeal. I can give you 7, I can give you less. It'll all depend on the information that's brought to me when we have a sentencing hearing.
Yes, ma'am.
You have every right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Valasila is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get with Ms. Holmes and get that information to her. She'll present it to me on your behalf when we come back.
This moment is the turning point. A felony erased. If she walks the straight line, one stumble. Prison. The judge isn't just warning her, she's drawing the map.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Burbank, you've got Andrew Jackson.
Your Honor, we have a deal
Okay,
with one caveat.
okay.
Yeah, let me.
I know yes.
Take a deep breath. He is going to plead today, and it's for 12 years.
Uh-huh.
The girl wants to come and make a statement, if we can reset it for 30 days or whatever it is.
We'll reset it for 1 week.
That's fine.
It's been reset enough. We'll do it on Tuesday on a jail docket. We've got jail here anyway.
He just needs to take care of some stuff.
He's got a week.
Yeah, that's what I'm
Yeah,
saying.
1 week.
Because,
It's not like this is a surprise.
No.
It's not. So
yeah,
you had 30 days to take care of this and time to get them here. So obviously, everybody knows this is a bit frustrating. Get the paperwork done.
but we're doing it right now.
And it will be 1 week to next Tuesday. Okay, all right.
He's gonna take a plea now.
Okay, yeah, you get that paperwork done.
Here, have a seat.
Good morning, you're Raymond Ryder, and this is 23-41597. Mr. Ryder's case is set for trial to begin with jury selection on Monday, the 8th, and what is the announcement? All right, obviously this is quite old, so it's likely to be numbered at the top. Any changes with regard to negotiations or rejections that I need to go over? Hey, can y'all hold it down? All right, so Mr. Ryder, stay in touch with Mr. Kelly. He'll know tomorrow after my docket what the trial order is, but expect to be here on Monday the 8th for trial, okay? All right, thank you.
Thank you, Judge.
All right, so you're John Garcia? Mark Garcia, sorry. And Mr. Garcia, it's very important that you're here on time.
Yeah, I'm trying. It's just so far from here. 2-hour drive to get here.
What?
I was trying.
Leave earlier.
I'm trying here, so it won't happen again.
So, Mr. Garcia, let me get you pulled up here just a second. I will recall that bond forfeiture. And Mr. Garcia, were you able to get anyone hired?
I'm getting close with the Crenshaw Law Firm. They're just discussing if they can drop down how much I have to pay right off the They wanted $5,000 to represent me, but they wanted $2,500. I'm seeing they drop down 15, and then we'll be good to go. So I should have that time for the next day.
Okay.
Just waiting on a call now.
Okay. All right, so what I'm going to do is reset your case about 30 days. It's important that you try to get him hired before that next court date. If it's not going to work out with Mr. Crenshaw, then you need to talk to at least 3 others and bring me those names. Okay? Step in front of the clerk. She'll give you a reset notice.
High-stakes negotiations aren't loud, they're quiet, tense, and expensive. $80,000 on the line, and the judge's patience thinning by the second. This defendant's past is a weight he can't outrun. Attempted murder, drugs, now a collision case. The courtroom isn't just judging his actions today, it's judging his entire history. That's the brutal truth of habitual offender law. 1 rejection, 1 gamble, and the next stop might be a 25. 2 life sentence. Courtroom choices don't come with rewind button.